All right, back up in the basement. We last time left off at Worldwide Volkswagen versus Woodson, and now we are on in-rem minimum contacts test, um, which is a fancy way of saying when you're exercising in-rem jurisdiction, you use the minimum contacts test. And for this case, we're going to look at a case called Shaffer versus Heitner. And I have it down as the Greyhound stockholder case. Now, this case, if you recall, I remember when I first heard it, I was a little confused by it, but then it made sense. Essentially, I think this case first established that when using in rem, you will use the minimum contacts test just like you do in personam cases. And the facts of this case, one, I have owners of Greyhound as the plaintiff here, and then as the defendants, I have Heitner. There is, like, keep in mind that when this was first filed suit in state court, the defendant was the petitioner at that point. So just so you can align the facts accordingly. But essentially, so Heitner filed a cause of action on Greyhound owners for some antitrust violation, and that being antitrust is a federal thing, but they tried it in state court. Now, Greyhound is incorporated in Delaware, and let it be known that I didn't put it in this case, but Heitner is in Delaware as well. Like, he filed suit in Delaware. But that's it, because otherwise the headquarters is in Arizona, and the owners of Greyhound they are domiciled, I believe, in Oregon. Delaware law at the time said that they can have in rem jurisdiction over Greyhound owners. So the court sequestered their property, so their stock. So like, this is the in rem part, so that they could show up in Delaware courts. Greyhound claims that Delaware can't do this because they don't have jurisdiction, thus violates the 14th, because we didn't know, right? And then Delaware Supreme Court sided with Heitner, and it went to the Supreme Court. So this case, the question was, does minimum contacts apply to in rem jurisdiction? And I've been saying that, but in rem, this was the thing that we ran into with Pennoyer, where courts will use the land, whatever it is, to hail somebody into court. But the issue of using in rem is that you can only claim damages as much as whatever the value of the land is. And so it's not necessarily the best way to do it. Goggins says, in rem it's not very common. 99% of the time we'll be dealing with SPJ with in personam. So, but anywho, regardless, a lesson is still had. So the holding here said that yes, that when looking at in rem, you apply the international shoe test as well. And that also means that you apply all the other parts of the international shoe test. And so you'll be using things like purposeful availment. You'll be looking at, like factors like foreseeability, and so on and so on. But as far as the facts go in this case, that it was insufficient to establish in rem SPJ through in rem, because it was just a stock. And so the court felt like one stock or a stock, maybe not a stock, but a share of stocks is insufficient. Moreover, if you were to allow it, there would just be a flood of lawsuits, because if you allow it for this stockholder, then what's going to stop you from any other stockholder, right? And so that is the lesson in Shaffer v. Heitner. giving you, if anything, this kind of gives you a better sense and a better feel for SPJ in the international street tests because, with specific personal jurisdiction, I think that's the vibe, shoe for life. So on to the next after this.